May please Lordship. My Lord, I beg to mention item number 19 on behalf of Subong Lajang, my Lord. My Lord, I'm informed that he is yet to receive instruction. So kindly list the matter after 3 weeks.
E-DIBA form submitting on behalf of
Subong Lajang.
Lachang. On the he submits that the learned government advocate is yet to receive instructions in this matter and prays for 3 weeks time for the same. Learned counsel for the Mr. Toshi Temjen Pongen. Learned counsel for the petitioner does not oppose this at prayer, hence prayer is allowed. Let this matter be listed after 3 weeks.
Much obliged.
Your Lordship. Lordship, in item number 22, and for the respondent number 2. Lordship, I would like to file a affidavit in opposition. So kindly give me 4 weeks time.
And there is three content, three related. Madam, here, madam, we have sent the order of DC, Dimapur, madam. This, madam, we filed a petition, madam, before under section 12. So, madam, if madam, this market, take time, we have no problem, but content matter also we come along with that. Today it is there.
Lordship, item number 3 is the content
Yes,
matter.
yes.
Item number 3.
Another development is that one of the developers is just not two minutes is already retired in a content. So he's required to a new one.
Lordship, insofar as that is concerned, I have not been informed about respondent number 2 having been retired. The content matter is item number 3. Lordship, that is in violation of an order of direction passed by the division bench way back in 19. And my lord, in this item number 22, they're challenging the award which was passed in the year 2012. Lordship, there's already an order passed by the division bench to implement the order.
Okay,
So, Lordship, let the content matter come up.
call up, because contempt matter is item number 2. 3, let the matter be called.
Yes. All right.
Item 20 also. Along with the content.
Item number 22.
Yes, so for I will make submission in the regard.
22, they are seeking time for taking instruction.
I'm seeking.
No, in this case, my lord, last question. Well, I have no objection, but the content matter is related to item number 22. So for my submission is concerned.
Lordship,
Okay, then let the item number 3 and 22 shall be taken up together
today.
May I please, my lord? I'd like to mention item number 6. Here I am for the private respondent. I'm yet to file my counter affidavit. So, my lord, I may be given 2 weeks' time.
Heard Mr. N. Long Kumar appearing for respondent,
For the sole respondent.
the sole respondent, and prays for 2 weeks' time for filing affidavit in opposition. And counsel for the petitioner does not oppose the said prayer. Hence, the prayer is allowed. List this matter after 2 weeks.
Our lordship, there's an interim.
The interim order shall continue till next day.
Yes, lordship. Lordship, I beg to mention item number 14. Lordship, here I'm appearing for respondent number 3 and 4. Lordship, I've sent the affidavit for signature, lordship. If the matter can come up for 1 week. Affidavit is ready. I've sent-
Heard Mr. N. Muzoi, learned government counsel who is
No,
the-
lordship, engagement. Engagement,
learned counsel appearing for respondent number 3 and 4,
lordship.
who submits that the affidavit in opposition is ready and same has been sent for signature, obtaining signatures of the
Lordship,
respondent,
lordship,
and prays for listing this matter after 1 week.
lordship.
Lordship, there is an interim past.
The Mr. What is your name?
Abel Ayami.
Mr. Abel Ayami, learned counsel for the writ petitioner, does not oppose the said prayer, hence the prayer is allowed. Let this matter be listed after a week. The interim order shall continue till next day.
May I please, your lordship, I would like to mention item number 34.
34,
Yes,
yes.
lordship, my senior counsel is on leave, so if this matter can be fixed on that 18.
You are appearing for? Zimo.
18.
Petition, you are appearing for petitioner.
Yes, we are for.
Heard Mr. A. Abel Ayami, learned counsel for the petitioner who prays for an adjournment on the ground of difficulty of conducting senior counsel. Also heard Ms. A. Ayami, learned government counsel, and Mr. Foseco Forte, learned counsel for respondent number 4, 5, who does not oppose the said prayer. Hence the prayer is allowed. Let this matter be listed.
18th next.
18th is okay. Let this matter be listed on 18th of October 2023.
Lordship, I would like to mention item number 35 as well.
Yes,
similar prayer, but Lordship, if this matter can be fixed at 16 or 17th. If there is possibility.
Lordship, I think 16 and 17, there are some matters already fixed. So
yes,
probably-
already matters are
Yes,
fixed,
Yes. So
which
probably-
will,
Let this,
let it come up after 2 weeks.
2 weeks. Lordship, there is already a vacation, so if it can be made on 18th, then.
But 18th also we
Yes.
we have fixed matters.
Yes, yeah, Lordship.
Okay, Lordship.
Third vacation.
Yes. Heard Mr. AIME, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the senior conducting counsel. Also heard Mr. N. Angami, learned government counsel, as well as Mr. Foseko Forte, who does not oppose the said prayer. Accordingly, the prayer is allowed. Let this matter be listed after 4 weeks.
Lordship.
Oblige you, Lordship.
May I please, my lord? Lordship, I beg to mention item number 24. Item 24, your lordship. Here, I'm yet to receive instruction from the department. If 3 weeks' time can kindly be granted to me, your lordship.
You have informed the,
Lordship, in fact, this morning I could not meet the senior lawyer, Mr. Siti Jamir, your lordship.
anybody from their team. You have to inform,
Lordship.
you will inform.
Yes, I will inform you, lordship.
Heard Mr. N. Angami, learned government counsel, appearing for the state respondent, who prays for an adjournment on the ground that he is yet to receive instruction in this matter. He also submits that he will inform the learned counsel for the writ petitioner regarding his prayer for adjournment. Considering the submissions made by the learned counsel, the prayer is allowed. Let this matter be listed after
3 weeks, lordship.
3 weeks.
Deeply obliged.
Next, Lordship. Lordship, I beg to mention item 5, Lordship. Lordship, here for the respondent. Lordship, I pray that this matter come up after 6 weeks, Lordship. The parties are contemplating to settle the matter outside the court.
Heard Mr. Foseko Forte, learned counsel for the
Respondent.
respondent. Also heard Ms. Lima Naru, learned counsel for the petitioner. Learned counsel for the petitioner, learned counsel for the parties have submitted that there is a possibility of parties reaching a compromise settlement in this case. And on that ground, an adjournment is prayed for today. Considering the ground, the prayer is allowed. Let this matter be listed after 3 weeks,
6 Lordship.
6 weeks.
Oblige, my lord.
May I please, your lordship? Your lordship, I beg to mention item number 7 to 10 on behalf of Inaoli. Kindly grant 3 weeks' time to file affidavit.
Objection, Your Worship.
Heard Ms. AIME, learned government counsel. Also heard Mr. Supangwating Worling, learned counsel for the writ petitioners. Learned government counsel prays for 3 weeks' time for filing affidavit in opposition, to which learned counsel for the petitioner does not oppose. Hence, the prayer is allowed. Let this matter be listed after 3 weeks. In the meanwhile, the respondent may file their affidavit in opposition.
Your lordship, similar prayer for item number 11 on behalf of Inaoli. 3 weeks to file affidavit, your lordship.
Item number 11, same order.
Your lordship, item number 14 on behalf of V. Jimo. Kindly grant 3 weeks' time to file affidavit. My
Right.
apologies, your lordship, 14 has been mentioned. And item number 16,
Item number 16.
yes, your lordship.
Lordship, I am also appearing on behalf of Ms. Apila Sankar for respondent number 5. She is in this course. Lordship, as such, kindly grant 3 weeks to file affidavit in opposition.
Heard Ms. AIME, learned government counsel, who prays for 3 weeks time,
3 weeks to file a rejoinder to the additional affidavit filed by the petitioner.
3 weeks time to file rejoinder to the additional affidavit filed by the
petitioners.
petitioner side. Also heard Mr. Senti Younger, who
Appears on behalf of Attila Sankam.
who is appearing on behalf of Ms. Attila Sanktam, learned counsel for respondent number 5, who is reported to be indisposed. Also heard Ms.
T. Atalichizo, your
P.
lordship.
Atali Chizo,
And your lordship, we have interim.
learned counsel for the petitioner, who does not oppose the prayer of the respondent side. Hence, the prayer is allowed. Let this matter be listed after 3 weeks. The interim order shall continue till next day.
Your lordship, item number 18 on behalf of additional AG LT Santam. Kindly grant 3 weeks to file affidavit.
Lordship, in this matter, I am appearing for respondents 129. If my presence can kindly be looked I have already filed my affidavit.
Heard Ms. AIME, learned counsel for the state respondent, appearing for,
LT Santam, additional AG.
and it is appearing for additional advocate general, Mr. LT Sanktam, who prays for 3 weeks time for filing
Affidavit.
affidavit in opposition. Also heard Mr. Senti Younger, who is appearing for
Respondents 1, 8, and 9, my lord.
respondent number 1 and
8, 9.
1, 8, and 9. Also heard Ms. Lucino, Viket Sono, appearing for respondent number 10. Stop. Mr.
Okay, so my lord, I'm appearing for the petitioner. I filed my affidavit in reply to the counter affidavit filed by the respondent number 1, 8, and 9. I also seek time to file my reply to the counter affidavit filed by the respondent number 10.
What is your name?
My lord.
I could not get it. You got it. Learned counsel for the petitioner submits that the petitioner side has submitted the reply to affidavit in opposition filed by respondent number 1, 8, and 9, and seeks time for filing reply to the affidavit filed by respondent number 10. Considering the submissions made by learned counsel for the parties, the prayer is allowed. Let this case be listed after 3 weeks. In the meanwhile, the parties may file their respective affidavits.
Your lordship, item number 20. Your state is here to file affidavit, so kindly grant me 3 weeks time.
No objection.
Heard Ms. AIME, learned counsel for the petitioner. Also heard Mr.
On behalf of my senior elder, Likase Sankam.
What is your name?
My name is Janos Nosep.
Write his name. Submitting on behalf of L. Likase Sanktam. Ms. AIME, learned government counsel, prays for time for filing affidavit in opposition in this case, to which learned counsel for the petitioner does not raises any objection. The prayer is therefore allowed. Let this matter be listed after 3 weeks.
Your lordship, similar prayer for item 21.
Same order, 3 weeks in for petitioner Supongwati Waling appears.
Your lordship, item number 23 on behalf of Livika, kindly grant 3 weeks time to file affidavit.
Heard Ms. AIME submitting on behalf of Ms. Livika, learned government counsel, and prays for 3 weeks time for filing affidavit in opposition. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks accordingly.
Your lordship, similar prayer for item 25 on behalf of Livika, 3 weeks to file affidavit.
Same order.
Much obliged. Your lordship.
Lordship, may I please, I'd like to mention item number 12 and 13, Lordship. Lordship, the pleadings are completed, Lordship. I have taken the concern of the counsel for the petitioner, if the matter can come up on Monday, coming Monday as admission hearing, Lordship.
Why admission hearing? Why not in admission hearing column?
Lordship, the petitioners, they are seeking a direction for regulation of the service, and the service has expired on September, Lordship.
Heard Mr. N. Muzoi, learned counsel for respondent number 2 and 3.
Lordship.
Also heard Miss
Asarutsa.
Asarutsa, learned counsel for writ petitioner. It is submitted by learned counsel for both sides that pleadings in this case is complete, and this matter may be taken up for admission hearing on 16 and 17. We have fixed hearing matters, Mr. Muzoi.
On 17, Lordship.
17 also. Because on that day again, it will be deferred. Let it come up after vacation. You take a fixed date. Let this matter be listed on 2nd of November
As a fixed item,
for
admission. hearing.
admission hearing.
Lordship. Oblige, your Lordship.
May I please, Your Lordship, I'd like to mention item number 30 on behalf of my senior. If this matter can come up next week.
Heard Ms. Asarusa, learned counsel for the petitioner, who prays for listing this matter on next week.
Third week.
You have informed the other side. You have to,
Yes, yes.
she also submits that she has informed the learned counsel for the respondent side. Hence, the prayer is allowed. Let this matter be listed after a week.
Right.
Please, Your Lordship. I beg to mention item number 32, Lordship. Lordship, the principal counsel is indisposed. Let it come up on 19 for hearing, Lordship.
Heard Mr. C.D. Rungseng, learned counsel for the petitioner, who prays for listing this matter on 19th on the ground that the leading counsel is indisposed today. He also submits that he will inform about this prayer for adjournment to the learned counsel for the respondent side.
Lordship, there is an interim order.
The-
Let it continue till disposal of the.
Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on 19th of October 2023. The interim order shall continue till next day.
May I please, Your Lordship, kindly allow us to mention item number 2 on behalf of my senior.
Item
Lordship.
number
2.
2. Yes,
Kindly allow us 3 weeks time to file our reply.
file your,
Reply, affidavit in reply.
Lordship, I'm for the Office of the Accountant General, Lordship. I have nothing to say. Because the petitioner was serving under a public sector. And
oh, okay, let them file.
for the state.
Heard Miss
Shisa Jamir.
C. Jamir, learned counsel for the petitioner, who prays for 3 weeks' time for filing reply to the affidavit in opposition filed by the respondent side, state respondent. Also heard Miss AIME, learned counsel for respondent number 1, 2, 3, and Mr. N. Muzoi, learned counsel for respondent number 4,
Lordship.
who does not oppose the said prayer. Hence, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship.
According.
Oblige, your Lordship.
Your Lordship, item number 31.
21.
31. Kindly fix this for hearing on Friday, 13.
heard Ms. C. Jamir, learned counsel for the petitioner. Who is for this government side?
I'm appearing on behalf of my senior Moa Jamir.
Who is representing state?
Itiba.
She has the Itiba, your lordship, and she has taken the consent.
Okay. Who prays for fixing this matter on
13.
13th of October? She also submits that she has obtained the consent of learned counsel for the state respondent. The prayer is therefore allowed. Let this matter be listed on 13th of October for hearing.
Lordship, item number 33. If this matter can be fixed for hearing on 19th of October.
Okay. Prayer is allowed. Same order. She has obtained the consent of the other side.
Lordship.
For admission, item number 1.
This is for pension of the petitioner's husband.
No, I could not get you.
Pension for the.
Pension. Okay,
Yes.
okay.
Petitioner's husband. My lord, I may be allowed to take your lordship to page 17 of the petition. Page 17, annex 1. May I read out, my lord?
This is for final disposal.
My lord.
Yes, my lord.
Okay.
Final disposal.
Yes, page 17.
My lord, this is Governor Naklan, Office of DC Twin Sang District, my lord. Office order number 131 of 70. Appointment contingency bed interpreters, my lord, interpreters. That is in Nakalan, they call it two pasi, two
Two language.
language, yes. It's not a single appointment, my lord, it is 16 of them together. The following persons under the establishment of DC Twin Sang are hereby temporarily appointed as contingency bed. The word contingency base.
Yes.
The passes in the scale of pay of rupees 100 to 175 plus inner line special pay at a rate of 20% of basic fees, subject to the minimum of rupees 35 in maximum of rupees 100 in all other allowances as are admissible under the existing rules from time to time with effect from 1/8/1970 forenoon against the post newly created, my lord. Scale of pay, of course, the word is contingency bed, but with effect from 1/8/1970 forenoon against the post newly created, it's a created post. White authority number APA 5/9/70/2 dated the 28th July 1970. So, my lord, it's not a single appointment. So number one, Mr. Sergeant Sarge, Dark Runner, Yamato. So all of them, they were serving under the Ruinsang Deputy Commissioner in various places. Number two is Pion Kipri. Number three is Pion Pongo. 4 Pion Pongo. 5 Pion Tupu. 6 is the petitioner's husband. 3 Ulysses Santem, NLC Chari. Earlier there was a border, a core of border. This we call it Nagaland Labor Corps.
Now Nagaland Labor Corps.
Yes, CORB is.
Okay.
So NLC Chari. So that is the petitioner's husband. 7 also is NLC Mangaki. 8 is contingency paid duck runner, lonely. 9 is NLC Tonokyu, 10 NLC Noklak, 11 NLC Noklak, 12 NLC Shamador, 13 NLC Tubu, 14 NLC Noklak, 15 NLC Noklak, 16 beyond Regional Council Misang. What I am trying to submit is that the name goes, hitting itself is appointment contingency pay. Interpreters. And in the order also it is contingency pay. But one fact is that it is in the scale up,
Scale of pay.
my lord. Then at the same time, against the post newly created by the authority number such and such dated 28 July 1970. So the name is one way misleading for the reason that it is in scale up pay, full-time basis against newly created post. So for all practical purpose, it is regular appointment. The appointment is purely temporary, so it is a temporary appointment, subject to termination of 1 month notice from either side. That is order dated 18/8/1970. Next page is the date given 18 August 1970. So it is from 1/8/1970. The petitioner have been serving in the skill pay in the sanction post. Prior to that, also he was serving in a non-pensionable post in the labor corps. So it is not only the case of the petitioner husband. It is a case of 16 of the different category who were serving under the DC 20. Then comes my lord. Annexure 2. This is dated 10 June 1974. The question is between that 1/8/1970 in the present, then effective from 1st June 1974. The issue is, the whole issue relates to that matter. Office order number 325/1974. Appointment grade 2 interpreter, my lord. Sri Ulysses Santem. Contingency paid the party Chari under the establishment of the DC Tuisang is, my lord, it is promoted. So your lordship is clear that when it is a promotion, the previous service has to be taken as recall. In temporarily appointed to the post of grade 2 DB. In the scale up, it was 100. It is now, since it is grade 2, 20 rupees, 120.
What was your original appointment as by 1/8/2070?
That is annexure 1.
That there you were appointed as Dobhashis
Interpreter,
interpret.
yes,
No, I want to understand to what post you were promoted. What was
it
your
is,
original?
yes, my lord, I'll come to that. If I may be allowed to read annexure 1. The heading is contingency paid interpreters.
Interpreters means Dobhashis.
My lord, but if I may allow to take your lordship, the order, the following person under the establishment of DC Twinsang are hereby temporarily appointed as contingency paid deposits.
Dobhashis.
My lord. So the word, use it interchangeably.
Yes.
That is with effect from 1/8/1970.
Then to which post you were promoted to grade 2 Dobhashis?
Grade 2, it must have been grade 3, my lord. Naturally, it has to be from a lower cadre to the promotion is to the higher cadre.
Okay.
So, my lord, is promoted in temporarily appointed to the post of grade 2 DB. So it has to be taken that below grade 2 will be.
No,
It will-
even if it is not grade 3, we may assume that from the contingency based interpreter Dobhashis, they were promoted to grade 2
My lord.
Dobhashis.
My lord. So in this case, subject to such and such, with effect from 1st June 1974, my lord. First was from 1st
August 1970.
Yes, my lord. Then the petitioner's husband service book was open, annexure 3. Here comes the confusion, my lord. Name is Ulysses Sangdam. Then page 21, which is not legible, so it has been typed out, my lord.
Yes.
Appointed as contingency paid deposit DB in the scale of 100 fixed. The graph of the confusion, my lord. It is not fixed. The appointing authority order is very clear that it is scale up pay.
Okay. Okay.
102 above,
But in the service book, it is mentioned as fixed pay.
my lord. This is clerical error at the time of opening the. However, it continues.
Yes.
Special pay, rupees such and such, dearness allowance, all the house rent allowance admissible under rules with effect from 1/8/1974 by order 18/8/1971. 70, that is annexure 1. So the appointing authority is very clear. So at the time of entry in the service book, there was a clerical error.
Yes.
Then continue. Appointed temporarily as interpreter grade 2 in the scale of rupees 120. So annexure 1 in 2 is covered in the service book. Only the thing is that it is written as fixed pay,
Yes.
my lord. Then page 24,
24.
yes. Oh, that's a- From Chari transferred to Long Kim extra assistant commissioner office. It is the same, under the same district. First was Chari, then to Long Kim. Then page 25, my lord. Page 25 is superannuation. Last one, on attaining the age of superannuation, my lord. Page 25. Sri Ulysses Sankam, interpreter grade 2. So the Pasi interpreter, they use it interchangeably. Is hereby allowed to retire from government service with effect from 1/7/81 for
Yes.
So the question arose because of that. 1/8/1972.
10 to 1981.
No. That is 1st June 1974. That is the promotion date.
Yes.
So the question arose, it is taken as contingency and fixed pay. So if it is removed, taken as non-qualifying service, then my service comes to 7 years something only.
Okay.
That is the whole issue, man. Then, without getting his pension,
And your case is that you were appointed against a sanctioned post,
yes,
against a newly created post
yes,
in a scale of pay
full-time basis.
on times on
My lord.
scale of pay.
Mal, on whole-time basis. First is scale up pay against post creation on whole-time basis, not in
And
content.
therefore that period of 4 years should be taken into consideration.
My lord.
That is your case.
My lord, that is my whole case. Then what happened, the petitioner husband died without getting any pension on 16/9/2002, annexure 4. Then it was only in the year 2007. The present petitioner submitted a representation to the DEC Twinsa. I may be allowed to read out, my lord.
Just a minute. If when you filed your representation first, annexure 5,
Annexure 5, it is term in place without date. However, the officer given a receipt on 2/8/2007.
on 2/8/2007.
My lord, It is only the receipt date,
Okay.
not my
Because your representation is undated representation.
mother.
Okay.
Malota subject. To the DC Twin Sound Nakalan subject, prayer for grant of service pension and family pension to my husband, late Ulysses Santam, retired capacity grade 2 from 1/7/1981 formal, and family pension from 16/9/2002 to Mrs. Tang Jenla Santam, wife of late Ulysses Santam, my lord. Sir, with due respect, I have the honor to put forward the following facts of my husband, late Ulysses Santam, ex-capacity grade 2, retired. Service particulars of your establishment before you for favor of your kind consideration in sympathetic order. One, that sir, my husband, late Ulysses Santam of Old Mangagi Village, District Tunsang, was first appointed as contingency bed capacity in the time scale of pay of rupees 100 to 175 per month, plus all other allowances as are recognizable under the existing rules from time to time, with effect from 1/8/1970 noon. After serving more than 10 years as an LC, Nakalan Labor Co. Under Circle Officer. Earlier it was Circle Officer, now it is called Extra Assistant Commissioner, the same establishment. Jari by DC Tunsang Order dated 18/8/70, copy includes the appointment was made against the post newly created by Order APA 519/70/2 dated 28/7/1970. Two, that my husband, late Ulysses Santam, was further promoted to DB grade 2 interpreter in the time scale of rupees 120 to 200 per month, with effect from 1/6/1974 by DC Tunsang Order dated 10/6/1974, copy includes. Three, that my husband, Ulysses Santam, was allowed to retire from government service on attaining the age of superannuation with effect from 1/7/1981 formal by release order dated 10/2/1981. In this connection, I beg to state here that though my husband was allowed retirement from government service as per rule, the pension and family pension have been denied on the ground that my husband had not completed even 10 years of service in the government, in allowed only service gratuity bank. However, on rechecking the service book entries in other relevant orders in documents, the following observation in discrepancies in the service book were found for reconsideration to grant pension and family pension to my husband, late Ulysses Santam. A, that as stated above in the first paragraph, late Ulysses Santam was appointed in the time scale of pay of the grade with all other allowances as admissible from time to time under the government, but it is seen in the service book entry that late Ulysses Santam was appointed as contingency paid fixed ₹100, which is quite contrary with the original order. In no yearly increment was granted for the years of 1, 2, 3, which falls on 1st August, which seems to be the main reason for, I cannot read, to grant and sanction pension and family pension, which may be seen in service book page number 4. B, as stated above in second paragraph, late Ulysses Santam, DB grade 2 retired, was promoted to grade 2 DB with effect from 1/6/74. which confirmed that the incumbent was entitled to get all service benefits from the date of his joining in service, that is 1/8/1974 known. Had the incumbent service from 1/8/70 not been counted as service, there was no point of promoting him to DB grade 2. Therefore, as per service rule, promotion means the previous service is counted as service and promoted. In view of the above mentioned facts, I earnestly request your authority to please re-verify my husband late Ulysses Santam pension case in process to the higher authority, as my husband had already completed 10 years, 11 months of service on the date of his retirement. Further, I beg to inform you that my husband, such and such, retired DB grade 2 expired on 16/9/2002 at 6 AM at Mangaki Village. An earlier action is highly appreciated. That is, thank Allah, wife of such and such. Then, my lord, the petitioner again,
What happened to this
my
representation?
lord, it appears that nothing was done. So again, see another representation. This is also not there. Receipt is given as 21/4/10, my lord. I may be allowed to read out.
This may be same contention.
My lord, yes. And Annexure 7, page 30. This is from the DC Twinsang to the additional chief secretary, actually Commissioner Nakalan. Dated 3rd November 2011.
This is on the basis of your second representation.
Likely, my lord. Subject forwarding of pension papers in respect of late Ulysses Santam, retired the Basi Twinsang. Madam, with reference to the subject cited above, I have the honor to forward here with the following pension papers in related documents along with service form in respect of late Ulysses Santam, grade 2 DB, under the establishment of DC, doing some for favor of your kind consideration in further necessary action, please, my lord. One is service form, 2 pension form, 6, 12, 14, 18 in part 2. Then 10 months service calculation, descriptive rule, thumb and finger impressions, succession certificate, no demand certificate, date certificate, birth certificate, and copy of appointment order. That is 3rd November 2011. That is from the appointing authority, that is the DC. To the commissioner. 1911 of 2000. Dated is written as 3rd November 2011, but signature of the DC is 1911.
Yes.
Then what the commissioner office has written, dated 15 September 2012, page 31. To DC Twinsang, subject authentication of earned leave encashment bill in respect of Ulysses Santam, grade 2 DB under ATC Longkin. Sir, in inviting a reference to your letter dated 5/6/2012, which I turn up, my lord. On the subject cited above, I am directed to return here with leave engagement bill along with service book and documents in respect of late such and such under ADC Longkin. And to request you to kindly give clarification why beneficial claims is submitted after a gap of 31 years of the said incumbent. So that is from the Commissioner of Nagaland to the appointing authority. 10, page 32, my lord. Dated 30th September 2004. From the DEC Twisa. Page 32, my lord. To the additional chief sick. It is to the Commissioner, my lord, practical. Subject resubmission of late engagement bill in respect of Ulysses Sometime to DB. ETC office Longkin. Madam, with reference to your letter number such and such dated
Yes.
2/8/13 on the subject of I am directed to resubmit here with the leave engagement bill in respect of late such and such. With the following clarification of delayed process. So the justification is given by the appointing authority. Madam, as one, late Ulysses Sangam was allowed to retire from active service with effect from 1/7/81. In his pension documents were processed but was unable to process in time due to complication in his length of service. In such a juncture, the incumbent expired on 16/9/2002, of which a photocopy of self-explanatory note by the claimants, saying such, now wife of late Ulysses is hereby enclosed. 2. With reference to your letter dated 15/9/2012, this office has submitted self-explanatory application along with comments for finalization of family pension by dated 23/12. Hence, you are requested to kindly consider the submitted case for earlier finalization, please. Dated 30/9/13 by the assistant.
So delay was explained,
Yes.
stating that
Yes.
the computation of his services.
My lord, that is
This complication is that whether
150
4 years would be taken into consideration or
my
not.
lord.
Okay.
That is the only reason. The reason for denial was that one. Then again, Commissioner Office, page 33. To the DC Twinsa. Subject return of service book in respect of such and such. Sir, in inviting a reference to your letter number such and such, I'm directed to return with the service book along with the leave engagement bill in respect of Ulysses Richard PB under the establishment of ETC Longkin and request you to properly verify the year update before issue of office order. Further requested to obtain non-approval certificate from the treasury officer. Also furnish the reason for the bill prepared in to break up for further necessary action. That is from the commissioner to the DC Twinsa. Then page 34. This is from the appointing authority, DC Twinsa.
Yes.
1st June 2013 to the Commissioner Nagaland Kohima. Subject resubmission of late engagement bill along with service book in respect of late Ulysses Sometime retired grade 2 DB ADC office Longkin. Madam, with reference to your letter number such and such, on the subject cited above, I have the honor to resubmit here with the deaf engagement bill along with service book after duly obtaining the required information in respect of late Ulysses Santa, retired PBETC Office Longkip. The following documents have been duly verified and corrected for favor of your kind consideration in further necessary action. One, the date of late Ulysses was on 16 September 2002. But due to clerical error, it was mentioned as 16/9/2010, the year. Actually 16/9/2002, but it was clerical error. It was mentioned as 16/9/2010. The matter has been verified and corrected and given initial signature in the header. No withdrawal certificate from the Treasury Office submitted for consideration, please. Then the Commissioner Office, 2nd August 2013, to the DC Twin South. Subject, left engagement objection in respect of science under the establishment of ATC Longkip. Sir, with reference to your letter science, that is Annexure 11, I am directed to return over the left engagement bill along with the service book in respect of Lake Ulysses Santa Mix TV2 under the establishment of ATC Longkip, and request you to kindly refer this office letter even number dated 15/9/12 and give clarification why beneficial claim has been submitted after a gap of 31 years of the said case.
Yes.
Then the appointing authority, page 36. No. This was not replied, my lord. Then page
What is page 36?
32, my lord. It
36.
appears that I've mixed up the annexure. It appears that Annexure 11 has been replied by Annexure 9. So there was
Annexure 11 has been replied by,
Annexure 9.
no, but by Annexure 8, page 31,
Page.
page 31.
Well,
31 was the query. Why 30? At page 31,
yes,
that
31,
why 31 years delay was made.
my lord,
It was replied by Annexure 9.
my lord.
Then by 11, again they put a query. That is my understanding.
My lord, yes, the same issue,
Same thing they have raised,
yes.
same query they raised again.
Then what happened is this, the issue.
By Annexure. By Annexure 8. Mr.
My lord,
Longchar.
my lord,
What I have understood that the government raised objection that why the
after,
pension papers were submitted after delay of 31 years. First objection was raised on 15th of September 2012
my lord,
by your Annexure 8. Annexure 8,
my lord,
to which the answer was given,
by
though
Annexure,
by Annexure 9.
my lord,
The answer was little bit cryptic,
Not direct, my lord.
not direct.
Yes.
Then they again raised the same query by annexure 12. Again, on 2nd of August 2020,
My lord, it appears that annexure 9 is the reply to annexure 12.
it cannot be. Because annexure 9 is in the year 2012. And annexure 9 is in the year 2013. Query cannot come before, after the answer.
My lord, yes, that is why it appears that I mix up the documents.
No, you have not mixed up.
Because-
They have raised query twice. That is my understanding.
Yes,
They raised query in the month of September. In
the last one was second
they raised this query for the second time by annexure 12.
12. Yes, my lord. That
First
is-
time by annexure 8, they raised the query,
My lord.
to which you answered,
My lord, it appears that my annexure 9,
yes.
with reference to your later number such and such, dated 2/8/13. That is directly to annexure 12.
Then this letter has been wrongly dated.
That
Annexure
No,
9
my
has,
lord, it is not
If you see the signature
wrong.
at the bottom part, it is
signature is 30,
39/9/2013.
but it is dated 30 September 2012. So either of the dates are wrong. Either the signature is,
Signature is 39/13. Office leader is 30 September, top is 12.
12.
But this document refers to
Okay.
2nd August 13, my lord.
Okay, so annexure 9 is the answer to annexure
12,
12.
because it refer to your letter dated 2/8/13. So signature is 13 is all right, but in the typing area, it is 12.
Okay.
So the confusion arose because of that now. Then when it was clarified, the office must have sent it to the AG, my lord. Annexure 13. Here arose the problem, my lord. Dated 7/10/2012 from the accountant general to the commissioner, subject pension case in respect of late Ulysses Sondam, retired TV interpreter under the establishment of DC Commission. Sir, in inviting a reference to your letter number dated 15/3/2014 and confirmation letter numbers dated 13/5/2014 on the subject cited above, I am to state that the pensioner retired on superannuation age on 1/7/1981. 5 office case numbers are inside. The pensioner has received service gratuity of rupees 15,193 point something in lump sum in TCRG of rupees such and such after retirement without receiving pension as the length of service, my lord. That is the whole issue. As the length of service of the pensioner was only 7 years in 1 month. That is after the promotion. In contingency paid for 3 years in 10 months only. So this was excluded and I'm not entitled. So moreover, for pensionary benefit, 10 years of regular services required, my lord. The AG That is as per the rule, 10 years.
Which rule says so?
49. This is pension rules 1972 is
Which-
adopted in Nepal. Then Rule 49. One of the
Pension rules. Central Civil Services pension. Yes, you may read.
49 is amount of pension. Rule 49, Malo. Itu same book, Hakiwuri itu same.
Rule 49, yes.
Malo. Amount of pension. Clause 1. In the case of a government servant retiring in accordance with the provision of these rules, before completing qualifying service of 10 years, the amount of service gratuity. In my case, gratuity was given, granted, shall be calculated with the rate of half month's emolument for every completed 6 months period of qualifying service. Then 1. The DA admissible on the date of retirement shall also be treated as emolument for the purpose of what? 2. Malo. 49(2) comes in the issue now. Clause 2, subject to the provision to sub rule 2 of rule 38 in the case of a government servant retiring in accordance with the provision of these rules after completing qualifying service of not less than 10 years, my lord. The amount of pension shall be calculated with 50% of emoluments. So in order to qualify for the pension, somebody must have 10 years. The amount of pension shall be calculated with such and such amount.
Only this rule mentions about 10 years qualifying service, or is there any other rule? Which makes us understand what do we mean by qualifying service? You may continue. Or you,
Retiring pension is given in Rule 36. Retiring pension shall be granted to a government servant who retires or is retired in advance of age of compulsory retirement in accordance with the provision of Rule 48 and 48A of this rule, or Rule 56 of FR, or Article 459 of CSR. So the conditions are retirement pension. Then 38 is invalid pension. Then my lord, 39 is compensation pension. 40 also is compulsory retirement pension.
No, Mr. Lord Chair.
Yes.
Your case is that this 4 years term should be computed while should be taken into consideration while computing the qualifying service.
My lord.
So only issue which appears to me
Yes.
that whether that 4 years is to be computed for 4 years should be taken into consideration for computing the qualifying service.
My lord.
On that, what is your submission?
My lord, my submission.
What is the position of rules first? How to assess the qualifying service? Your submission is that as because the appointment was against sanction posts
My lord.
on a payoff scale. So mere mentioning of word contingency
My lord.
would not make it contingent appointment. Is that your submission
My lord.
or anything else?
My lord, qualifying service is given in Rule 13.
Rule 13.
Yes. Of the CC's rules.
Yes.
13. Commencement of qualifying service. Subject to the provision of these rules, qualifying service of a government servant shall commence from the date he takes charge of the post to which he is first appointed, either substantively or in an officiating or temporary capacity. In my case, the nomenclature is very clear, contingency, which doesn't come under this. That is the whole issue.
Yes.
Provided that the officiating or temporary service is followed without interruption by substantive appointment. In my case, it is a promotion since it is a substantive appointment or when it is promotion, the condition clarifies. Provided that officiating or temporary service is followed without interruption by substantive appointment in the same or another service or post, my lord. Provided further that in case of a government servant in Group D service post who held a lien, I was holding a lien, or a suspended lien on a permanent pensionable post prior to such and such 1950, service rendered before attaining the age of 16 years shall not count for any purpose. Then, in case of a government servant not covered by A, service rendered before attaining 18 years shall not count, except as compensation criteria. C, the provision of clause B shall not be applicable in the cases of counting of military service for several pensions. This illustration then Rule 14. Conditions subject to which service qualifies. Clause 1, the service of a government servant shall not qualify unless his duties in P are regulated by the government or under conditions determined by the government. The first appointment is from the Accountant General, the copy. So it is from the consolidated fund of the state. For the purpose of Rule 1, the expression service means service under the government and paid by the government from the Consolidated Fund of India or local fund administered by the government, but does not include service in a non-pensionable establishment unless such service is treated as qualifying service by the government. So in the case of the deceased, when he was in the labor corps, it was not a pensionable post. But the moment he was appointed as interpreter, that is a pensionable post. In the they were
So in 71 itself, you
70.
70, in the year 70, you were appointed as interpreter.
My lord. 1970.
Okay.
Then was it the salary was paid from the contingency fund of in the state. Page 18 is copy to Accountant General Assam Meghalaya Nakal Shillong. When it was a consolidated Accountant General, the Nagaland is under the Shillong. So first copy is to the AG Assam Meghalaya Nagaland in Shillong, page 18 after repetition.
Okay.
So it is from the consolidated fund of the state.
Yes.
Only the question is, in this case, what happened is this. The question is contingency. That is why they've taken it to be a fixed pay, not in a pensionable post. That was the confusion. So I may be allowed to continue, my lord.
Yes.
Then page 13, page 36, annexure 13. Why the accountant general has found that I am not qualified because of the record which was placed before them. So what is the report speaks itself. DCRG work and after retirement without receiving pension, as the length of service of pensioner was only 7 years, 1 month in contingency pay, my lord. DP for 3 years, 10 months only. Because of the nomenclature, the whole issue was the AG also interpreted as per the provision. I understand that. But it was because of the service book, which was a clerical error. See, they are clear that if it is 10 years, yes. But what they are counting is that since is 3 years in 10 months was uncontinuous. The EG rule says 3 years in 10 months has been on contingency pay, which has not been regularized. When it is a promotion, regularization or confirmation is not an issue. When somebody is promoted, the previous service has to be taken as regular. That is the rule.
Unless you are regularized, you cannot be promoted.
Mano,
That is your submission.
somebody is that why promotion? Since I was. working
Unless
as-
you are in a regular service,
Yes,
question of promotion does not
No,
arise.
no.
That is your
my
submission.
lord, that is my
Okay.
submission.
Okay.
If it is a new appointment, yes. But when it is a promotion, it is from the previous post.
Yes.
Yes. Since 3 years in 10 months has been on contingency bid, which has not been regularized and cannot be counted for qualifying service. Hence, as per the rule, a government servant will not get the benefit of pension and only service gratuity will be entitled. No doubt the deceased have received gratuity in TCRT. So what happened? The petitioners in a legal notice. Dated 4/3/2015 to the commissioner, to the secretary, PNR, DEC Twinsang, the AG. The legal notice was responded by page 39, my lord. Annexure 15. This is from Home Department, JAB. 27 May 2015. To the Commissioner Nagaland, subject legal notice, reference Office of the Accountant General memo dated, that is Annexure 30, dated 7/10/2014. Sir, I'm directed to refer to your later number such and such on the subject cited on the above cited subject and to convey the approval of the government to rectify the lapses as per the PNR OM dated 26.
What are these lapses?
The lapses was contingency.
Okay.
That was the whole confusion arose because of that. So this is convey the approval of the government to rectify lapses as per the PNR OM dated 26 November 2009. This is for your information and necessary action. So from the Home Department, government level, Commissioner Appen informed. The 26 November 2009 is my annexure 24 in the writ petition, page 48, the last page of the writ petition. This is the OM 26 November 2009, ANAR, Government of Nagaland, OM, subject counting of contract at top period for retirement. Many departments have sought clarification as to whether the services rendered by employee on contract at top work charge appointment should count for fixing up length of service. The standing guideline of the government is that the period of that service rendered is being counted for increment, leave, pension, and other service benefit except seniority. The regularized work charge employees are also entitled to count in full their continuous work charge service towards pension benefits. Therefore, it is further clarified that the contract at top work charge period thus render will count for determining length of service for pension purpose in terms of Nagaland Retirement from Public Employment Act 2009. The above decision will be equally applicable to both the officers, staff coming from outside the state who are appointed on contract basis in the employ of the state government in similar cases. So whatever be the nature of appointment, it will be counted for the pension. Yes, seniority, it will be from a different date. In my case, from the date of my promotion. But for pension, yes, it is to be from the date of the initial appointment. That is the OEM. But the rule is very clear that when it is promotion, you cannot promote somebody who is not in the service.
Okay.
So, my lord, that is what the issue is raised by the AG. Then, Annexure 15, it is the government, Home Department, if rectify the lapses as per the OEM of the government. Then, Annexure 16, my lord. This is from the commissioner, that is the directorate of the administration. Office of the AG memo dated 7/10/24, that is Annexure 13, the same reference. Because it is a reference of the government, Home Department communication. Sir, with reference to this subject above, I am directed to forward here with a copy of the Home Department number, such and such, that is Annexure 15. In to convey the approval of the government to rectify the lapses as per being near OEM dated 26/11/2009. This is for your information and further necessary action, please. So, from the government, from the commissioner, that is directorate of the administration commissioner, to the DC. Then DCF by 2nd July 2005, Annexure 17. Legal notice. It is to the commissioner, sir, inviting a reference to your letter dated 4 June 2015, that is Annexure 16. In Home Department, later dated 27 May 2015, that is Annexure 15, my lord. The reference by the DC is, first is 4 June is Annexure 16. Then 27 May 2015 is Annexure 15. On the above subject, the following lapses are being rectified, my lord. The DC is the appointing authority from the D1. So rectification is given as such. That Sri Ulysses Santam was serving as NLC porter in Chari subdivision, for which his appointment letter is not traceable. So it is not there. In the petitioner also do not know. While serving as NLC porter, he was appointed as contingency bed TB in the scale of Bay of rupees 100 to 175 plus ILP special pay at the rate of 20% of basic pay, subject to minimum of rupees 35 and maximum of rupees 100. With all other allowances, appointment letter includes, that is Annexure 1 in the present proceeding. This appointment was made by order dated the 18 August 1970. That is Annexure 1 of the present proceeding. In pursuance to newly created post by authority dated 28 July 1970. So the appointing authority, authority is saying, yes, it was against the sanction post in the scale up pay. Then what happened, although the appointment letter has mentioned C pay, the Basi, he was appointed against the sanction post with rubber scale up pay, along with 15 other as stated above. Annexure 1, Malota had taken your lordship, it was not a single appointment, 16 of them. So it has been clarified by the appointing authority. Further, it is also to mention here that this appointment has been erroneous. Entered in the service book as contingency paid in the scale of pay of rupees 100 fixed. That is the whole issue,
That has been now clarified.
which is being considered as a clerical error. So when it is a clerical entry, the appointing authority is the right person to see what is what. So it is taken as a clerical error. This is not on its own, but based on the appointment order. Hence, the qualifying length of service should be considered from the day he was appointed as contingency paid TB. In the then existing scale of pay as stated for all purpose, the incumbent was further promoted to grade 2 in the scale of pay of 120 to 200 per month, right? Dated 10 June 1974. It may also be pertinent to cite the OM dated 26 November 2009, which is self-explanatory. This is for favor of your kind information in further necessary action, please. So when this was clarified, again, Annexure 18 is from the AG, which is a continuation of Annexure 13, my lord, 7/10/2014, which was clarified by the government, the commissioner office, in the appointing authority, that is the TC. Instead of acting upon it, EG have
Again, raise that issue.
raised the issue not to the appointing authority, not to the department, but
Why
to
to
the
vigilance? To the director of deputy DIG vigilance and anti-corruption.
my lord.
Why?
That is what exactly why. When the appointing authority is saying that, look, there was a clerical error, but it is rectified as per the OM. Then he received
To verify the genuineness of the case.
my lord, I have no grievance upon it. Okay, for pension or anything, since take it that 30 plus years. So normally also it should be, if there is doubt, it has to be verified. So I have nothing against it. But as your lordship has pointed out clearly that when the government have rectified, why do you have to write it to the vigilance? It is copy-paste of Annexure 13. To the vigilance director, subject family pension case in respect of such and such, DB under the establishment of DC twins. Sir, in inviting a reference to the subject cited above, I am to state that the pensioner retired on superannuation age on 1/7/1981. That is a correct statement. Right? Your case number 11-0 of 82 in 3. The pensioner has received service gratuity of such and such in DCRG of such and such. After retirement without receiving pension, as the length of service of the pensioner was only 7 years, 11 months, and contingency paid DB for 3 years in 10 months only. Moreover, pensionary benefits, 10 years of regular service is required. This is copy paste of Annexure 13. Now, Srimati Sajin has applied for family pension after the death of the husband. Moreover, the following discrepancies have been noticed. 1. The name of wife at the time of retirement in the family members. List is Srimati Ten Chan Sangla. In the date of birth is 1/7/1936. Whereas in the Form 14, the name is written as Srimati Tenjala and date of birth as is 15/6/75. But in birth certificate, it is written as 16/7/1950. So there was discrepancy.
Now this is regarding the petitioner,
The petition.
new query. Okay.
So for this, if there is discrepancy, yes. Little be an inquiry to that is fine. 2, the actual date of the government servant is 1/7/1906. However, the service book is overwritten as 1/7/1946. It is therefore requested kindly to verify the genuineness of the case in return to this office for further necessary action from this end. So, copy to PNR.
So this was also clarified.
My lord. So what the director have written is page 43, annexure 9. Dated shall we go by the signature? It's 7/16. Because dated, it appears 11 July 2016, but sign on 8 July 2016. So this is to DC. For what? Inquiry in requisition of documents. I'm to refer to the subject cited above that in view of an investigation being conducted by the commission pertaining to the pension claim of in respect of Ulysses DB interpreter under your establishment. The concerned officials who forwarded the said family pension is required for examination in certain clarification. Therefore, you are requested to direct the concerned officials under your establishment to appear before the IU, Sri Sajin Sach, at Vigilance Police Station, Kohima, on 22nd July 2016 at 12 p.m. It is also requested to furnish the following original document in respect of late Ulysses Sangdam, retired TV interpreter under the establishment of DC Twin South. First appointment in the post of DB interpreter, service book, personal file, succession certificate in all other relevant documents. Therefore, the desired document be kindly furnished to this commission on or before 22nd July 2016 from the Director of Vigilance in Anti-Corruption. Then, by office letter dated 28 November 2016, my lord.
That clarification was given.
My lord, they have done as per the later dated sign such from the DC to Insan. Verification into the genuineness of monthly family pension claim by Srimati Sajin Sach, DB under the establishment of DC to Insan. Number dated 8/6/16, that is annexure 18. And to refer to the subject cited above into state that the preliminary inquiry was conducted by this commission to ascertain the genuineness of the family pension claim by Srimati Tanjan Sangla, wife of Sajin Sach, DB retired under the establishment of DC Twin South. During inquiry, the genuineness of the pension claimant has been established on physical verification. It has also been established that the actual name of the pension claimant is Srimati Tenjala in her actual date of birth is 25/11/1940. Secondly, the admissibility for the family pension benefit against the service of such Ulysses Santam should be taken up as per the relevant government OM copy enclosed. Thus, the family pension claim made by Srimati Tenjala, wife of late Ulysses Santam, retired DP, is recommended to be genuine, my lord. That is an investigating agency. Therefore, the matter is ordered for initiating further necessary action from your end. Then, my lord, when this was clarified by an independent agency, then what the AG did is this. Page 45. Now they have gone to the PNR. First was to the department, second to the vigilance. When it both clarified it, they wrote to the secretary, PNR. Dated 27/2/17. This is nothing but repetition of annexure 13 and 18, isn't it? 13 and 18. Family pension case in respect of such and such. Madam, in inviting a reference in this office letter number dated 7/10/14, that is annexure 13, and number dated 8/6/16, that is annexure 18, copy enclosed. On the subject cited above, I have the honor to state that the pension retired, that the pension retired on superannuation age on 1/7/1981. White Office case number 110 of 82 in 83. That is your case, pension case in the AG. The pensioner has received service gratuity in lump without receiving pension, as the length of service of the pensioner was 7 years, 11 months. In contingency repetition, 3 years in 10 months only. It may be stated that after counting half of the period of the contingency service, they are trying to cut it into half. The incumbent did not reach the required minimum qualifying service for pension. For retail reference, home department pension number such and such contingency period is not been regularized. When it is been regularized by the appointing authority, the question doesn't arise. I therefore request you kindly to intimate whether such cases can be admissible for the purpose of granting pension and family pension. So this is the third copy paste. Then what happened is this impugn later, annexure 22, page 46. This is a communication between the AG and the PNR. Not a copy to the petition. 11 July 2017. AG, subject, family pension in respect of late such and such. Sir, I am directed to refer to you later dated 27/2/17.
Mr. Longchair,
Yes,
I'm taking 2 minutes break.
madam.
Yes.
So, my lord, page 46. This is from the India. It doesn't refer to your own memo, that is page 47.
How it counted as 9 years, 1 month?
My lord, it appears that they make it count half. It appears. That is the only reason. But once the government have taken the decision, the appointing authority, the question of breaking up or removing it doesn't arise. The government have already rectified and taken that it should be counted. No other person can say that it will be half or not counted. It is the appointing authority who will decide, not other department. So, my lord, I'm directed to refer to your such and such. From your office and the cited subject into state of the matters when examining in consultation with the finance department into convey that the total line of service rendered by Mr. Such and such is only 9 years. 1 year short of minimum qualifying service. 10 years to be eligible for pension. As such, the proposal for grant of pension is not covered under any extent rule. This has the approval of Secretary PNER.
The same government is saying,
My lord,
this is a letter from the
PNER,
government department,
PNER, not the Home Department.
but
Home, I'm under the Home Department.
another department of the
Yes.
same government.
It's the same government, which has issued the page 48.
Okay.
Page 48 OM dated 26 November 2009 under the signature of the Chief Secretary, which says that it will be counted for pension. Yes, not for the seniority. So, and under Secretary writing a letter against the OM issued by the Chief Secretary of the BNR department. So this has to do, number one. Is a deputy secretary writing against the 26 November 2009, signed by the Chief Secretary of the BNR, against their own memo, signed by the Chief Secretary. It doesn't, it defies all logic. The next one is, my lord, this is counting of seniority. It's all the same. In case of ATOC, in case of contract. In both the OEM, that is by the Home Department JAP. Counting of seniority for service rendered on ad hoc appointment. So it is by the Home Department. Since all the administration is under the Home Department. After careful examination, it has been decided that if such ad hoc service is continuous, followed by regular appointment in confirmation, the period of ad hoc service thus render will count for increment, leave, pension, and other service benefit. But seniority in the garage should count only from the date of regular appointment and should follow the order of merit given by the NDAC or the selection board. So also is in the contract.
Okay.
The period of such service thus render will count for increment, leave, pension, my lord. In other service benefits. This is in continuation of this 1975. The present 26 November 2009. My lord, I've submitted my, there are two. One is written argument. I've submitted before your lordship. Submitted on. Written argument. Is it written?
Yes, I have it.
Written submitted, written argument. Written argument was submitted way back on 2022. It will be before your lordship in the file.
7/6/2022.
No. 2022. After I submitted the written argument, the petition was heard in full. And after that, I was directed to submit written submission, which is 7/6/2022. My lord. Your lordship.
I got 7/6 one, but this 2/2, is it separate?
Yes. Since it was 2nd February 2022, and after the hearing, it was directed to submit for written submission. I've submitted on 7/6. My lord, 7/6 will cover.
Okay, so
If I may be allowed to read out. Number one,
today you will not allow others to, other matter to take.
my lord, if you lordship, my lord, in basic is 1/8/1970.
Okay. No, I,
1974, which is promotional. So if your lordship may just want to have a look at the submission.
you can point out the main submissions.
My lord,
Your main submission is that 3 years period should be taken into consideration.
my lord,
In support of your submission, have you relied on some
Okay.
authority?
written submission, one. What I'm trying to see is that 1970 post is sanctioned in the scale of pay,
Okay,
then copy to the Accountant General Assam Mikalaya Nakalan in Shillong.
yes,
That is
that you have,
consolidated fund of the state. Then the appointment order makes it clear that Sanctum was working under NLC Nakalan Labor Code. Chari in appointed to DB in time scale up pay with effect from 1/8/70, which is paid from the consolidated fund. That is through the AAG. And further promoted to grade 2 DB with effect from 1/74. 1st June 74 by such and such. Thus, number one, he held a clear lane in the sanction post with effect from first appointment 1/8/1970. Lane is clearly defined in FR 9 of 13.
no, I'll go through it. I'll go through your written submission.
My lord.
Anything which you want to make special point, special, bring it to special
No,
notice. Otherwise, I'll go through it.
that is sufficient. My lord, I have submitted the book list on the same date, that is 7/6/2022.
Yes.
Running page, I've given there. Running page 4 in 5. What is lien? That is it. Fundamental Rule 9. Clause 13, lien means the title of a government servant who holds substantively, either immediately or on the termination of period such and such. Then five is promotion.
Why question of lien arises?
My lord, they are trying to say that I was not holding a substantive post.
During that three years?
Yes,
Okay.
I am saying that from the D1 it is whatever be the nomenclature. I was having a lien. Then page 5. 13, clause 13, that is from the extract, it is given C. C, on promotion, how it has to be taken about the previous. If the recruitment rule do not prescribe any provision, an officer promoted on regular basis after the DPC, etc., will have all the benefit that the person confirmed in that lower grade. Then this is 1972. Page 10. State of Assam versus Rakhava Kupala Chari. Whole bench of the Supreme Court. What does it see? Page 10, para 13, the last one. The respondent to a writ petition cannot be allowed to attack its own order as a respondent. They've already admitted everything was fine. As per the rule, it was a clerical error. After that, they are attacking their own order. A deputy secretary going against their own OEM. They cannot be allowed to. Then 2019 then SCC, it is not directly involved to me, but full page of the Supreme Court framing running page 37. Para 34. That third line, such and such, in whole that the services rendered even prior to regularization in the capacity of work charge employee, contingency, paid fund. See that I am a contingency paid fund, even though I'm paid from the consolidated fund of the state. Employees or non-pensionable establishments shall also be counted towards the qualifying service, even if such service is not then preceded by temporary or regular appointment in a pensionable establishment. Even though it is not directly related to my case, but just imagine that I retired as a contingent. Even without preceding by regular appointment or promotion, even then, the Supreme Court is clear that it is to be counted for the pension. The other are cited to the precinct. Much obliged.
Yes. Mr. Angan.
May I please, my lord? Lordship,
You are appearing for,
the state respondent, your lordship.
is anybody from AG?
Yes.
Okay, okay. Because it is the AG who is opposing, and state respondent has also stated that he has rendered only 9 years of service.
Yes, yes, yes. After going through the rules,
Okay.
lordship. Now, your lordship, my learned friend has pointed out the appointment order. That is 18/8/1970. Your lordship, I am bringing my lord here for the fact that if you see the nature of appointment of the petitioner, the nature of appointment, which is at page 17, annexure 1 of the writ petition. I just wanted to show the nature, how the petitioner is appointed. And on what basis the petitioner is appointed. Therefore, allow me to refer this particular order, appointment order, your lordship.
Yes.
It says, your lordship, appointment contingency paid interpreters. There is no confusion to the appointment or to the nature of appointment, as it clearly says, appointment contingency paid interpreter, contingency paid interpreter. And it starts with the following person under the establishment of Deputy Commissioner Tuensang, I hereby temporarily appointed as, your lordship, nature of appointment, as contingency paid Dubashi in the scale of pay. So the nature of appointment is contingency paid. There cannot be any dispute on this, your lordship. So the nature of appointment, your lordship, is since it is contingency paid. And thereafter, when he was given a temporary status by reappointing him as grade 2.
No,
Interpreter.
that was promotion.
Yes, your lordship, promotion and appointed as grade 2. It is not just promotion. If
But
it is,
How can you promote a contingent worker unless he is in against a sanction post?
lordship, however, your lordship, the issue is not whether promotion was given to him or how the promotion was given to him.
That is
The
not-
issue is whether the period that he has served as contingency can be calculated
Yes,
for the length of service. That is the issue, your lordship.
yes, but for that, your own notification is there.
Uh,
OM is there.
2009. Your lordship, I will satisfy my lord. The 2009 is no more applicable. And even if it was applicable, your lordship, it will not be applicable in the case of the petitioner, your lordship. I will satisfy my lord, your lordship.
Yes,
Now, your lordship, as I pointed out, nature of appointment of the petitioner is, by this order, is contingency paid. And this is not disputed by the petitioner himself. Thereafter, your lordship, as the petitioner has pointed out, by another order, 10th of June 1974, which is at page 19, annexure 2,
yes, he was promoted.
promoted and appointed. Promoted and appointed, your lordship. So his contingency, and if you see, your lordship, this promotion and appointment order, 10th June 1974, it says, Sri such and such contingency paid Dubashi under the establishment of the Deputy Commissioner is promoted and temporarily appointed. Now the status temporary comes.
Okay,
It states, your lordship, under the establishment of Deputy Commissioner, Tuensang is promoted and temporarily appointed to the post of grade 2 DB in a scale of pay. So, your lordship, if you see from the initial appointment date, 1970 to 10 June 1974, the petitioner has rendered a contingency service period of exactly 3 years and 10 months.
yes,
3 years and 10 months, your lordship. And if you refer the, your lordship, the date where he was superannuated from service, which is available in the service book, your lordship, it says that he is retired from service with effect from 1/7/1981.
yes.
1/7/1981. That means, your lordship, the temporary status that he enjoyed through this order dated 10/6/1974 through the date of retirement, that is 1/7/1981. Your lordship, the petitioner has rendered a service of period of 7 years and 1 month. So contingency period, your lordship, for a period of 3 years and 10 months, and temporary period, service of 7 years and 1 month.
Then why have you mentioned that he has rendered service of 9 years?
Lordship, yes, as per the rule, there is a rule where the contingent period that the person has served can be calculated. Now, basing on that rules, we have calculated and it comes out to 9 years, which is 1 year short of 10 years, which is,
Which rule?
your lordship, I have annexed it in my affidavit in opposition, your lordship. Page, your lordship, it starts from page 7, annexure A. This is under the CCS pension rule, my lord. My first affidavit filed on 13/11/2018, your lordship. Under Rule 14, page 7, annexure A, my lord.
Yes.
Under Rule 14, Government of India Order 1. Which your lordship will find it at page 8. Counting half of the service paid for contingencies with regular service. Half of the contingency service. So by taking that 3 years and 10 months into a round figure of 4 years, we took out the 2 years service as per this rule and added into that 7 years of temporary service, making it 9 years, your lordship, in total. But before going into that, your lordship,
Yes.
if I may be allowed to go back to the initial appointment order, your lordship. Here I wanted to point out something, my lord. In this initial appointment order, the petitioner has correctly stated that since it starts with the sentence, the following persons under the establishment of the Deputy Commissioner to Insang are hereby temporarily appointed. The following person under the establishment of Deputy Commissioner to Insang. And your lordship, the order ends with para, the sentence, there's a last para. In the interest of public service, the above persons are posted to their present respective posts. Now, as confirmation the letters given by the Deputy Commissioner to Insang, as well as in the representation of the petitioner herself, submitted to the Deputy Commissioner to Insang, the petitioner husband, before he was appointed as a contingency paid dubashi or interpreter, he was appointed as porter. He was appointed as porter. And therefore, this sentence, in the interest of public service, the above person are posted to their present respective post is mentioned.
What it means, present?
Lordship, the present respective post means the petitioner's husband was appointed as porter and posted as et chare. Et chare. And therefore, when he was appointed again on a contingency paid interpreter, he was kept under the same subdivision that is Chare. Now, your lordship, this statement of mine, your lordship, can be seen from the representation submitted by the petitioner herself at page 27. Page 27 of the writ petition. Your lordship, I'll just read the relevant part. Page 27 of the writ petition, your lordship.
Yes.
Now, your lordship, only para one, your lordship may allow me to read. Just the para one, starting with that, sir. I may be allowed to read my.
Yes, yes.
That, sir, my husband, late Yalosen Sangdam of Old Mangaki village, district Tuinsang, was first appointed as contingency paid Dubashi in the time scale of pay, such and such, plus other allowances as admissible under the existing rules from time to time in Nagaland with effect from 1/8/1970 after serving more than 10 years as NLC under Circle Officer Chare. So when he was appointed as contingency paid Dubashi, your lordship, he was already serving as porter at Chare subdivision under NLC. Now, your lordship, then the question arises as to why the petitioner is not claiming that land of service, which has already served 10 years as porter, your lordship. Why the petitioner is claiming her husband's service only from the date, that is 18/8/1970, not 10 years back, your lordship, is for the fact that, your lordship, NLC, that is the Nagaland Labour Corps, where the petitioner husband was appointed as porter, is actually brought out by the notification dated 5 July 1968. Your lordship, I have already placed it before my lord on the previous occasion when this matter was taken up for admission hearing. Notification dated 5th July 1968.
What it says?
It says, your lordship, the government of Nagaland hereby makes the following rules to govern the constitutions and administrations of the Nagaland Labour Corps. Namely, this rule will be called the Nagaland Labour Corps Rules 1966. Now, under this notification, your lordship, Section 3 speaks about the constitution of these rules. And under Section 3, Clause 6, subclause B. Clause 6, subclause B, it states,
3(6).
subclause B.
Yes.
It says, all posts under the Nagaland Labour Corps will be non-pensionable posts paid from contingency under the appropriate head of account. So it is a non-pensionable post. This is the reason why.
He is not claiming.
Yes, because the rule says so. The rule says so.
Therefore, he is not claiming.
Yes, your lordship. Because the rule does not provide for him to claim a post under that. Because the rule says so, your lordship. Now, this is the reason why, your lordship, in the order.
Okay.
In the initial appointment order which the petition is claiming, that is 18/8/1970, at page 17. At page 17 of the writ petition. against the name of the petitioner's husband, which is a serial number 6 in the list. It is mentioned Sri Yalosya Sankam NLC Chare.
Now, what is your submission that from this date, whether he continues to be a porter or a Dobhashi?
No, he continues to be an interpreter appointed on a contingency basis.
Therefore, he is claiming.
Yes. Now, therefore, he is not claiming the porter's service that he has given as a porter, but he is claiming from this date
Yes.
when he is appointed as a contingency paid. So, your lordship, under this contingency paid also, your lordship, there is a rules which provides whether the service that has been rendered as a contingency can be applied or can be taken into account when a person goes on retirement. That is the whole issue, your lordship. And therefore, allow me, your lordship, allow me to take to the service book at page 21.
Yes,
Page 21, your lordship, of the writ petition. I'm sorry, my lord.
yes. 21A is the type copy.
Yes, 21A, your lordship, I have not given a type copy. But
Because 21 is not legible.
yes, yes.
You can read from 21.
Yes, your lordship. Here, it is stated that appointed as contingency paid DB, contingency paid DB in a scale of ₹100 fixed plus special pay. So when his service book was opened, it was again mentioned as contingency paid. And it is mentioned fixed.
Fixed is the error which you admitted later on.
Lordship. Yes,
That
but
this was a clerical error.
yes, this, according to the deputy commissioner's report, it is a clerical error, your lordship. However, your lordship, whether he was given that scale of pay or was it given a fixed pay only is already explained by the petitioners in her representation at page 27. Page 27, your lordship. The last para, if I may be allowed to read.
This.
The last para, 3A. That as stated as stated above in the first para, late such and such was appointed in the time scale of pay of the grade with all other allowances as admissible from time to time under the government, but it is shown in the service book entry that late Yolese was appointed on as contingency paid fixed of ₹100, which is quite contrary with the original order, and no yearly increment was granted for the year 1971, 1972, and 1973.
Which is contrary to the appointment letter.
Yes,
He should have.
but then it was given, but then it was given as a fixed pay.
But for that, there was no sanction.
Yes, but is the petitioner contesting this then, your lordship? Then why was he given a fixed pay? No, your lordship, he has never raised this issue in the writ petition. Now, therefore, your lordship, if a petitioner is claiming that he has completed the mandatory period of or required period of 10 years as per the CCS pension rules, then the CCS pension rule has to be applied in total. Not just that part which suits the petitioner or not just the part that suits the state government. It has to be applied in total. What does the rule say, your lordship? If I may be allowed to take your lordship to the rule itself.
Who may be regarded as a contingency worker? How to judge? What is the test?
Lordship, actually contingency workers are not.
Whether contingency worker can be appointed against a sanction post.
That, your lordship, has to be verified, your lordship. I cannot say that. But the rules of 1972, the CCS pension rules, even the latest one, 2021, it says, your lordship, if I may be allowed to read. Application, that is rule 2. Applications of the CCS pension rules.
Yes.
It says, your lordship, save as otherwise provided in these rules.
Yes.
Safe as otherwise provided in this rule, these rules shall apply to the government servant appointed on or before 31st day of December 2003, including civilian government servant in the defense services appointed substantively to civil posts, civil services, and posts in connection with the affair of the union, which are born on a pensionable establishment, but shall not apply to A, railway servant, B, person in casual and deliberated employment, and C, person paid from contingencies. We are concerned with C, Your Lordship.
What it means paid from.
Yes, Your Lordship. So a person who is paid on contingency, this rule cannot apply to them. Now, this rule does not say that a person paid on contingency, but a scale of pay is being given to him. These rules of the CCS pension rules can apply to them. It does not say so. It says, this rule shall not apply to person paid from contingencies. So how is the petitioner paid, Your Lordship? That is the question. If I may be allowed to refer to the initial appointment order again, Your Lordship. Page 17 of the writ petition.
Yes.
If I may be allowed to read. The following persons under the establishment of Deputy Commissioner Twin Sang are hereby temporarily appointed as contingency paid. Dubashi.
Yes.
So, Your Lordship, the rules itself says that this rule cannot apply to a person who is paid from contingency. The petitioner here before this court, Your Lordship,
No, okay. So the question is whether you are a contingent worker
yes,
or your status is
something else.
something else.
Yes, Your Lordship.
That is the
issue. Now, the rule says, because why I'm referring to this rule is because, Your Lordship, the petitioner are here before this court seeking a relief from the state government to grant them the pension under this rule, under the CCS pension rules. And therefore, these rules has to be read all together, Your Lordship. So when the rule says that these rules cannot apply to a person who is paid from contingency, the period that the petitioner has served as contingency paid Dubashi cannot be counted, Your Lordship. This is the reason why, Your Lordship, the respondent number 2, that is the PNR department, Your Lordship. That is why, Your Lordship, the PNR department has in its letter dated 11/7/2017, which is annexure 22, page 46 of the writ petition. While calculating the length of the half length of service that can be calculated as per the CCS rules, the contingency period that was taken into consideration and added to the total number of years that the petitioner's husband has served the department as on a temporary status, which comes to 9 years and which is 1 year short of the minimum qualifying service under the CCS pension rules. The PNR department has issued this letter to the accountant general for the fact that these rules cannot apply to the person who is paid from contingencies, as the rule says so. These letters are issued, Your Lordship, not at the whims of the responding authorities, but as per the rules only, Your Lordship. Now, Your Lordship, my learned friend has referred to the office memorandum dated 8 July 1975, 19th November 1975, which are annexed as annexure 23, page 47. This, Your Lordship, if you read the memorandum, the content of the memorandum does not, as far as the petitioner's case is concerned, it will not cover his case for the fact that, Your Lordship, if I may be allowed to read the office memorandum, it says, Your Lordship, if I may be allowed to read.
Yes, at page
47, my Lord.
yes.
Subject is accounting of seniority for service rendered on ad hoc appointment. The first memorandum, that is 8 July 1975, page 47, my Lord.
No, they are relying on the
Page 48,
page 48.
Lordship. Shall I read this then, Lordship? It says counting of contract ad hoc period for retirement. Many departments have sought clarification as to whether service rendered by an employee on contract ad hoc work charge appointment should count for fixing of length of service. The standing guidelines of the government is that the period of such service rendered is being counted for increment, leave, pension, and other services benefit except seniority. Now, the next line is important, Your Lordship. The regularized work charge employees are also entitled to count in full their continuous work charge service towards pensionary benefit. The regularized work charge employees, Your Lordship, are also entitled to count in full their continuous work charge service towards pensionary benefit. So this particular office memorandum will come into play the moment a person is regularized from contract ad hoc work charge.
So he has been promoted without being regularized.
Lordship, because here my learned friend has been stating that it should be taken or it should be considered as regular appointment. The initial appointment order should be considered. Lordship, it clearly in the appointment order, it clearly says that the appointment is purely temporary, subject to termination of 1 month notice. Now, Your Lordship, if the service of the petitioner is regularized, the petitioner will not be here before this court, Your Lordship, because he will be enjoying his pension by now. It's because the petitioners
No, he has not been given pension only because of your opposition that he has not completed the qualifying period of service. No other ground.
qualifying service of temporary in nature, not regular, Your Lordship. If the petition service is regular in nature, Your Lordship, then there is no ground for us to go into all these things. Stating that he has not completed 10 years, he has completed just 7 years of temporary service, 3 years as contingency. All these issues will never be raised by us, Your Lordship, if his service is regular in nature.
So his 7-year service is also not regular,
No, Your Lordship.
but you have never raised this, taken this plea. That your only plea of the government as well as of the AG
Yes,
is that he has not completed
10 years.
10 years of qualifying period.
Correct,
It is less than
correct,
for 1 year or
Yes.
3 years less.
correct, correct. Now, why that is so is because, Your Lordship, even if a government employee's service is not regularized, but since we have adopted the CCS pension rules, it says that a person who has served on a temporary service nature is entitled to pensionary benefit. Even though his service is not regularized, subject to 10 years of continuous service. That is why all these issues we were raising up, Your Lordship.
No, in gist, what is your submission? Why this office memorandum of 26 November should not be applicable to?
26, Your Lordship, yes. Because his service is not regularized.
Okay.
His service is not regular, and this is meant for the government employees who were appointed on contract, work charge, or ad hoc. And subsequently, their service are regularized. So what will happen for the period that they have served as contract, ad hoc, and work charge? This is what the office memorandum speaks about. It says, Your Lordship, it says, see, that is why, Your Lordship, here it starts with, Your Lordship, it starts with a sentence such as this. Many departments have sought clarification as to whether the service rendered by an employee, see, a service rendered by an employee on contract, ad hoc, work charge appointment should be counted for fixing of length of service. So the period that an employee, a government servant, has worked on contract, ad hoc, or work charge before his service is subsequently regularized.
And your submission is that the present petitioner's services are not regularized.
Not regularized. And therefore, this office memorandum, Your Lordship, is not applicable. Even otherwise also, Your Lordship. Even otherwise also, Your Lordship. I'm concluding my submission, Your Lordship. Even otherwise also, Your Lordship, this office memorandum 26 November 2009 is already superseded. It's already superseded by a notification dated 29th March 2017. If I may be allowed to place it on record, my lord. Notifications dated 29 March 2017.
What it says?
Lordship, it says, I'll just refer to para 6, my lord. Here the subject, Your Lordship, the subject is counting of contract, ad hoc, work charge, substitute period for retirement purpose. This is the subject. And I refer to para 6 on the next page, Your Lordship. May I read, my lord?
Yes.
Now, therefore, it has decided that the period of service rendered on ad hoc, contract, work charge, substitute period, which is followed by regularization or regular appointment without break, or gap in service except resignation, but notwithstanding the cases of the resignations taken up with proper permission for another appointment shall be treated as public employment and include in calculations of land of service for the purpose of pensionary pension under the Nagaland Retirement from Public Employment Second Amendment Act. Then the next para, Your Lordship, para 7. It says, this supersedes all office memorandum on the subject, including the office memorandum dated 1 August 2012. So on the subject, this particular office memorandum supersedes all other office memorandum, meaning thereby, Your Lordship, this office memorandum 26 November 2009 is already superseded. Now, Your Lordship, this particular office memorandum was already in operation. Then the petitioner has filed this writ petition for the fact that the petitioner has filed this writ petition on 8/12/2017.
So this will be applicable.
Yes,
Para 6 would be.
paralysis will be applicable, Your Lordship.
Para 6 also says that it is applicable to the post in case which is followed by regular position
Correct,
or regular appointment.
Lordship, or regular appointment.
So whether their promotion to the post of grade 2 Dobhashis can be regarded as regular promotion.
No, Your Lordship, because the nature of appointment, as I've shown, my lord, was a contingent basis, Your Lordship. And
Their second promotion is also contingent basis.
yes, Your Lordship, the second promotion order is temporary. Temporary, Your Lordship. The contingency is gone, Your Lordship. After the second appointment is made, it was given a temporary status. And it says the appointment is purely temporary, subject to termination of 1 month notice. Not only that, Your Lordship, if you see at the front part of the order, page 19.
Yes.
It says, "Sri such and such contingency paid DB under the establishment of the Deputy Commissioner to Insang is promoted and temporarily appointed." So a temporary nature comes into existence, Your Lordship, by this order. In the first order, it is contingency paid basis. Now it says the contingency paid DB is promoted and temporarily appointed.
Okay.
Lordship. By concluding my submission, Your Lordship, I'd like to refer to the applications of the CCS pension rules again, Your Lordship. It clearly says that it cannot apply to a person paid from contingency. Lordship, the petitioners is appointed, paid on contingency for a period of 3 years and 7 months, Your Lordship. Therefore, that period cannot be counted, Your Lordship. Which will be against the rules. I am deeply obliged, my Lord.
May I please, Your Lordship?
Yes. You want to continue now or after break, after lunch?
Lordship, I'll continue. My submission will be very short. I'll just give a short submission,
How much time will you take?
just 5 minutes. Not more than 5 minutes.
Or we'll take it up at 2. We'll take it up at 2.
Yes, yes.
Item number 3 and 22.
Yes.
My brother, he fixed a date on because is required to implement the party respondent on new one.
That was his submission when he made mention.
Yes.
Lordship, all right, Lordship, since they have informed me now, let them furnish me the details today, sir. I have to issue notice again to the new incumbent.
In item number 3,
Item number 3.
heard Mr. Imti Longjam, learned counsel for the petitioner, also heard Mr. S Medhi,
Just give it. I'm for respondent three.
SK Medhi,
Respondent three.
respondent number 3,
Each Chakrabarti for
B Chakravarti for
1 and 2.
respondent number 1 and 2, and Miss A Gayan
Four.
for
4, 5.
learned CJSC, appearing
CGC.
Central Government Standing Council,
CGC.
Central Government Council, appearing for respondent number 4 and 5. It is submitted by learned council for the, it is submitted by Mr. Medhi, learned council for the respondent number. It is submitted by learned council for the respondents that respondent number 3, two has already retired, and therefore there would be a necessity of impleting the present incumbent in this case. On this Mr. Mr. Longchem, learned counsel for the petitioner, prays for some more time.
After they furnish me the details.
Prays for some more time for impleting the present incumbent as respondent number
6.
Now, in place of respondent number 2.
Not in place, my lord, but will be added. Because respondent number 2 will be there.
Okay. Respondent number impleting the new present incumbent as new respondent in this case. He also requests learned counsel for the respondents to provide.
Already provided.
No, he has submitted that. No, then this order is not necessary.
No, he said, he has sent me to the phone. That's what he said, but I have not seen it.
We'll provide.
Learned counsel for the respondent also submits that they will provide the details of the present incumbent so as to facilitate the impleting the present incumbent as a new respondent. Let this matter be listed again on
14th of November.
14th of November.
And item
Then
22.
as regards item number 22,
Lordship, regarding that, I would like some time to file my counter affidavit, so let it be listed again on 14th.
heard
And
Mr.
respondent number 2, my lord.
Item number 22, heard Mr. SK Medhi, learned counsel for the petitioner. Also heard Mr. Imti Longjem, learned counsel for respondent number 2, who prays for some more time for filing affidavit in opposition. The prayer is not opposed by the learned counsel for the petitioner, hence same is allowed. Let this matter be listed. Along with, you have one listing
Not along with my lord, but
on the same day,
On the
listed
14th.
again on 14th of November
November.
2000.
Well, in this case, affidavit from respondent 1 and 3 also required, state respondent in this case. So,
Who is appearing for state?
State of Nagaland.
Any government council, Miss Jaime, who is appearing in this case?
20.
22.
They have not filed.
No,
Your lordship, kindly grant some time.
14th,
Miss Jaime,
14th.
learned government council prays for time for filing affidavit in opposition on behalf of respondent number 1 and 3. The prayer is allowed. Let this matter be accordingly listed on 14 November.
Obliged.
Yeah, Mr. Lordship. Lordship, I beg to mention item number 26.
Yes,
Lordship, can it be listed on Thursday?
who is for the other side? You are for the
Petitioner, Your Lordship.
heard Miss Thuya Krulu, learned counsel for petitioner who prays for an adjournment today on the ground of personal difficulty of the engaged counsel. And also request for listing this matter on
Thursday, Your Lordship.
Thursday means 12th, on 12th of October, Miss AIME Learned Government Council does not oppose the said prayer, hence the prayer is allowed. Let this matter be accordingly listed on 12th of October 2023.
Lordship, I beg to mention item 4. Let this matter be listed after a week, Lordship.
Item number 4,
Yes, Lordship. Let this matter be listed after a week, Lordship.
heard Mr.
W. Marshall, Lordship.
W. Marhu,
Lordship.
Learned Council for the
I am for the respondent number 5.
respondent number 5. You have informed Mr. Pongner.
No, Lordship, but I'll.
You have to
them, Lordship.
inform them.
Yes, I'll do that, Lordship. I'll inform Lordship.
Who prays for listing this matter after a week. He also submits that he will inform Learned Council for the petitioner. Therefore, the prayer is allowed. Let this matter be listed after it.
Mindful.
Now. 26 to 29. Four. Oh. Boy. Oh, 27 na. Three, 4, 22.
Okay. We, credit neighbor. Go to there. Whatever. We'll also do the association. And then are you calling other people? I actually do not. Isolation. Item number 37, break पिछले लोला जो है और नए आरो इचे दे ना तुम फोन कॉल करी दिले नोरा तो बड़ा एडवांस पा ओए अच्छा ठीक है कुछ ये भी बड़े बड़ा I think you have to admission fix as it. Yeah.
Albert, itu nih, kita lebih itu ini nih video tu lah, kami on board kita, saya break tu benar ni lah, itu X mana tu nih, itu kami on board juga, ini like meeting awal kan ya, nah, kelas, oh, around 165 na lah, break kasi running ni meeting awal lah,
ঠিক আছে এইটো strategy লৈ তো on কৰো না
kaya lo ni around 165 na lah, kaya ulit na.
ঠিক আছে ঠিক
Net tu je.
Hindi mo na. Item number one, number one.
아직까지 고래 곰지 대략 팁 받아야
Yeah. If he is not, if sir is not bringing new fact, I'll finish. Yes, yesterday also the last case was mine. After that was mine. No, we are done. Sir? No, hardly 5 minutes. Yes, because sir is you know the sound that sound. Yesterday or yesterday.
How much? I see too much.
Thank you. No, we are looking for that. Correct. You may lose the case, but after contesting, even if you lose the case, also there's, you still will not feel good inside. But experienced person like Sir, very difficult, always following us with one thing or the other. Knows how to corner us. Yes. Very true. No, sir, very straightforward. That's the best thing about it. Well, if sir, I'm even more extra within our. I'm another review petition no, this issue petition no.
I will supposed to
Review
Yes.
Please, Your Lordship.
You're for AG.
Yes, respondent number 7.
Okay. What is your name?
P. Honbeni Izum. I'm appearing on behalf of my senior, Joshua Sheki.
P.
Honbeni Izum.
Monbini Isum.
Yes, Lordship.
R7, yes.
Lordship, given the submission of the state respondent, the Accountant General has nothing much to say. However, I would like to clarify the stand of the Accountant General. If my lord may kindly look into the affidavit filed by respondent number 7.
Yes.
Lordship, that the Office of the Accountant General has never denied the pension of the petitioner. However, we have just followed the rules, pension rules laid down by the government. And if I may take your lordship to paragraph 12 of my affidavit.
Yes.
That with regard to the statement made in paragraph 25, 27, 29, 30, and 32 of the petition, the answering deponent states that as per pension rule as quoted under Article 368 of the Civil Service.
You are reading paragraph number?
Number 12,
12. Okay.
page number 3.
Okay. Yes.
That with regard to the statements made in paragraph 25, 27, 29, 30, and 32 of the petition, the answering deponent states that as per pension rules as quoted under Article 368 of the Civil Service Rule Regulation CSR and Rule 14, the nature of appointment of contingency paid is different to that of work charge ad hoc, where on regularization of service, 50% of the service as contingency pay is counted for qualifying service for pension benefits. In the instant case, the official served form 18-1970 to 16-1974 as contingency paid service, that is 3 years and 10 months. After counting 50% of the contingency paid service DP, the qualifying service comes to 1 year and 11 months. The official was appointed temporarily as interpreter grade 2 with effect from 1/6/1970 and retired on 1/7/1981. That is 7 years and 1 month. Hence, after adding together the 1 year 11 months served under contingency paid service and temporary post of 7 years, 1 month, the total qualifying service is 9 years. However, the minimum qualifying service required for pension is 10 years. And my lord, because of this rule, the Office of the Accountant General has written to the PNR department clarifying whether the petitioner husband will service will be taken as regular or not. But the same.
They have also said that 9 years.
Yes, lordship, because as per the rule, it comes only 9 years. If I may take your lordship to paragraph number 10, page 3. That with regard to the statement made in para 22 of the petition, the answering department states that as per PNAR department letter dated so and so dated 11/7/2017, the PNAR department has not granted its concurrence for pension in respect of late Ulysses Sangtam.
Yes, Mr. Long. What is your response to this?
My lord,
That rule comes into,
Yes. My lord, Rule 14, my learned friend have relayed, that is government affidavit, page 7, annexure 1. Rule 14, conditions subject to which service qualifies. The service of a government servant shall not qualify unless his duties indeed are regulated by the government or under conditions determined by the government. 2, for the purpose of sub-rule 1, the expression service means service under the government in paid by that government from the consolidated fund of the state. So when the rule is clear, the question of going to the order or decision doesn't arise. So under order rule 14, the lead service is clearly covered. Then, my lord,
and your response to Mr. Angami's plea that rule 2A or something of CCS rules C excludes contingency.
my lord, that is what I'm trying to see. My lord, his service. Rule 14 is clear. When rule is clear, the question of going to the government of India's order or decision. These are clarificatory when the rule is clear. Rule 14 is clear. Consolidated fund of India or local fund. That is from the accountant general from the day one. My lord, am I clear to that effect?
Your salary when you were appointed as
Nomenclature
contingency based interpreter,
my lord.
contingency. What is the language? Contingency paid interpreter for 4 years. Then also your salary was paid from Consolidated Fund of India of state.
Yes,
From where you are saying?
yes. Page 18. The appointment order is page 17.